Hello and welcome to the Minimum Competence episode for Monday, October 21st, 2024. I'm your host for today, Andrew Leahy, a tax technology attorney from New Jersey. On today's episode, we cover DJI suing the Pentagon over military ties, Eli Lilly's lawsuits on copycat weight loss drugs, Fox News legal team move, and New Jersey Transit's patent immunity battle. Let's remember, Mondays are for fresh starts, and read today's legal news. On this day in legal history, October 21st, 1876, the West Publishing Company, founded by John B. West, published its first legal reporter, the Syllabi. This marked the beginning of a transformation on how American legal professionals accessed and utilized case law. The Syllabi aimed to provide Minnesota lawyers with timely, accurate, and reliable legal information, distinguishing itself through its promise to be, quote, prompt, interesting, full, and at all times thoroughly reliable. Over time, the Syllabi evolved into the Northwestern Reporter, which played a significant role in shaping the broader national reporter system for case law. West's innovation was groundbreaking because it standardized the reporting of judicial decisions across multiple jurisdictions, creating a centralized, accessible body of case law. The National Reporter system expanded to cover decisions from various courts in different regions, making it easier for lawyers to research case law beyond state boundaries. This system eventually became the foundation for modern legal research and was essential for the creation of tools like Westlaw, which revolutionized legal research with digital access in the 20th century. It is worth noting the development of a centralized legal reporting system, while transformative, also raises important access to justice issues. West Publishing's dominance in legal reporting and the eventual emergence of paid research platforms like Westlaw created barriers for individuals and smaller firms with limited financial resources. The high cost of accessing comprehensive legal databases places those without means at a significant disadvantage, potentially hindering their ability to conduct thorough legal research or build strong cases. This disparity underscores the ongoing challenge of ensuring equal access to legal resources, a critical factor in promoting fairness within the justice system. China-based drone manufacturer DJI has filed a lawsuit against the U.S. Defense Department challenging its inclusion on a list of companies allegedly linked to Beijing's military. DJI claims the designation is inaccurate and has caused substantial financial harm, including lost business deals and a tarnished reputation. The company, which controls over half of the U.S. commercial drone market, argues it is neither owned nor controlled by the Chinese military and seeks removal from the list. DJI alleges that the Pentagon did not engage with the company for over 16 months regarding the designation, leaving it no choice but to pursue legal action. The Pentagon has not commented on the suit. DJI is also facing increasing scrutiny in the U.S., with concerns raised about potential security risks from its drones. Earlier this week, U.S. Customs stopped some DJI imports under the Uyghur Forced Labor Prevention Act, though DJI denies any involvement with forced labor. Meanwhile, the U.S. House has passed a bill to ban new DJI drones, pending Senate action. Eli Lilly has filed lawsuits against 3 medical spas and online vendors, Pivotal Peptides, Mango RX, and Genesis Lifestyle Medicine, overselling unauthorized versions of its weight loss drug Zepbound, which contains tirzepatide. These lawsuits, filed in federal and state courts, accuse the companies of false advertising and promotion, including selling products without medical prescriptions and making unverified claims about the drug's safety and efficacy. Pivotal Peptides allegedly marketed tirzepatide for research but sold it directly to consumers, while Mango RX offered an unapproved oral version of the drug. Genesis was accused of selling compounded tirzepatide with vitamin B12, a combination that Lilly says is unsafe and untested. Lilly's lawsuits follow earlier legal actions against other companies for similar offenses. The drug maker aims to protect consumers from potential health risks and seeks to stop the defendants from selling these products, as well as pursuing monetary damages. 4 prominent labor lawyers from Baker McKenzie's New York employment practice, Paul Evans, Chrissy Katzenstein, Blair Robinson, and Jeffrey Sturgeon, have moved to Paul Hastings, leaving Baker McKenzie short 1/3 of its employment lawyers. The team has represented Fox News in several high-profile employment disputes, including defending the network in cases involving former host Britt McHenry and a COVID-19 workplace exposure claim. The team has also worked with clients like CBS Broadcasting, Paramount Global, and Panda Express. Their move to Paul Hastings follows collaborations with the firm's employment lawyers, and they plan to continue growing Paul Hastings' client relationships. The transition strengthens Paul Hastings' East Coast employment practice, enhancing its capacity in complex employment matters, including Title VII representation, pay equity, and class actions. Paul Hastings' leadership sees this as a significant boost, especially ahead of regulatory shifts tied to the 2024 presidential election. New Jersey Transit Corp., or New Jersey Transit for my fellow Garden State residents, is facing a patent infringement lawsuit from Railware Inc., which claims New Jersey Transit is using its rail worker safety technology without permission. New Jersey Transit is seeking to dismiss the claim, asserting a sovereign immunity as an arm of the state of New Jersey. The issue is complicated by the fact that NJ Transit operates in both New Jersey and New York. While the Third Circuit, which covers New Jersey, has previously ruled that New Jersey Transit qualifies for immunity, the Second Circuit, which covers New York, uses a stricter test to determine state immunity. This case is significant because it could set a precedent for how sovereign immunity is applied across jurisdictions. Railware argues that New Jersey Transit's immunity claim is invalid, citing the agency's independent operation and non-state funding. The case also touches on broader legal debates about when state agencies can claim immunity in patent cases. New Jersey Transit is awaiting a key ruling from the New York Court of Appeals on whether it is immune from another lawsuit, which could influence this case. If conflicting rulings emerge from different courts, the matter may be escalated to the U.S. Supreme Court for resolution. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than minimum competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, a mask tells us more than a face. Good luck decoding that one.